things. I'm joined by Immigration Attorney Jon Velie. We'll have also Attorney Yesh and Ashley potentially join us. But with that being said, I'm going to give the mic over to Attorney Jon. Thanks for being here.
Thanks, Pierre. Appreciate it. Sorry, everyone. Google Meet hijacked me. I just figured out what they're doing. It's the link to this one, and then it says, "Do you want to do Google Meet?" And I didn't know it was different, so apologize. I was sitting in the wrong place. Hope everyone's having a good Friday as we head into summer, as we head into the peak of the H-1B season. We think it's really important to talk about the 221G as you're going into H-1B season. 221G is the reference to a regulation. That's what it is, Section 221G. And that's one of the ways that a consulate, the U.S. consulate, which is under the State Department, can deny a visa. It is a denial. It's also called administrative processing. It's also where they send the case back, or they may investigate and things like that. So I want to talk about 221Gs. I'd love to hear other folks that are having those issues, what some of their facts are without divulging any confidentiality, any attorneys that have those issues. But let me give a couple examples of why cases might get a 221G. Well, sometimes they're just overloaded, right? They don't have enough people at the consulate that day, and they write a little note and they say, "We're looking at this." Administrative processing or something like that. They check the box and they don't even tell you why it is, right? So it may be nothing. They may be overloaded. They may not have enough folks there. They may not understand it. It might be a new person. Sometimes, and a lot of times, the 221G is because USCIS has tagged either the beneficiary or the petitioner. So the beneficiary could be tagged for a couple of reasons. One of the things that we're seeing is that if the beneficiary had obtained a visa through another company, and that another company has been determined to have an issue, maybe not your company or your client's company, but another company, maybe they did a double registration, right? And if they did a double registration, a couple things could happen. One, they may find that that double registration, in their opinion, was a finding of fraud. So they make a statement of fraud and then they alert USCIS. And that finding of fraud could attach to the beneficiary, even if the beneficiary didn't commit fraud, right? It also could mean that their visa got pulled out of the lottery, right? It was a lottery visa. They had it. They said it was it was fraud or a misrepresentation, which isn't even fraud. And they say because of that, their visa was never allocated to them. So when they go to a new place, they don't have a visa to go to them. And you sometimes don't know that. The beneficiary sometimes doesn't know that. You may never know that. Another reason for a 221G might be the petitioner, the current petitioner has had a statement of fraud and they don't know that. They may learn of it in the with the investigation, with the questions from the consular official. They may not. The consular official may tell them that we think you've committed fraud. They may not. They may ask questions, and then if those questions create an inconsistency in the 221G, then USCIS might issue a notice of intent to revoke that visa. That might be sometime after you've done the consulate visit. You don't know that it's coming, and all of a sudden they give you something that says that we've learned new facts that were not present in the H-1B, and because of that, we don't think it was a bona fide job offer, and therefore we're going to revoke the underlying visa. And there's time between that, and you don't always know what that is. So 221Gs are really serious. And people with 221Gs that are filing new H-1Bs need to understand that these very well may be connected, right? We've talked about these in the other ones before. Maybe this is the first time you've tied into this, but let me give you a little insight on what is happening in immigration right now and take you back a little ways. So if you've heard this before, I apologize. Sometimes it's good to reiterate it, but it's often better to know the why. It helps you understand things, helps you apply for it. So what is happening? So in March of 2020, the IT Serve case came down. The IT Serve case was filed by an association of tech companies, basically on what it felt was the improper or arbitrary and capricious handling of the processing of H-1B visas by USCIS. They filed it against USCIS officials. Cuccinelli was the last one in charge when it came down, and that's why it's called IT-Serv versus Cuccinelli. And what the court said is that USCIS was being too restrictive in its analysis of, in particular, staffing companies, right? Now, what were they asking that they shouldn't have? Well, they're asking for third-party contracts, which many times meant third-party letters, which in fact were some sort of affirmation by a client of the staffing company, if the staffing company was the petitioner, that the person would be working at their location. That's what they would say. And the third-party contract was proof of that. Third-party letter was also some degree of proof of it. And they also were asking for itineraries. You need to tell us what these folks are going to be doing for the entirety of the requested period. You can get an H-1B up to 3 years. So what are they going to do for 3 years? The court said USCIS misunderstood the business model. That was a polite way of saying it, because USCIS did not misunderstand the business model. It just didn't like the business model. I've got an issue with that personally. I think the business model is fine. I think it's a good business model. I think staffing companies have at least twice in history have really stepped up. One of them recently with all the layoffs of the big companies, Google and Amazon, and a lot of big companies laid off a lot of folks. Staffing companies picked them up, put them in projects, kept them going. They did it again in the downturn, 28, 29, 2010. And it was in 2010 where USCIS, instead of thinking, hey, what a great way to keep these jobs in America, helping these American companies and really helping American jobs who would have lost it if they had to outsource the tech to another country like India. Instead, they went hard. They invented the Neufeld memo, and they started employing a case called defensor. Defensor is a case that said the real employer is the end client. And if the real employer is the end client, then all these H-1Bs get denied. Now, the end clients didn't want to hire them for whatever reasons, probably because they wanted to be more temporary, didn't want to pay them as employees, wanted to have contractors come in. But the staffing companies did. And the staffing companies would hire, train, fly, pay for the immigration services, handle all the insurance, get them ready to go, find projects, put them in the projects, a lot of valuable things they were doing. And that was their business model. That's how they make money, and there's nothing illegal and wrong with it, but it's often come under scrutiny. So in 2020, the IT-Serv case says you can't be asking all these things about contracts and itineraries, and people hire people all the time on work they're going to be doing. We might hire a new lawyer tomorrow. We don't always know what case they're going to be on, and that you're looking at this too narrowly. So USCIS settles the case after the court comes down, changes out its memo, removes all those things, takes all those things it had to do, except for you have to have the work at the time of filing. That's what's left. Well, the time of filing is really another way USCIS is saying, is it a bona fide job offer? Is it real? Right? It has to be real. That's what we always teach our attorneys. Like, is this project really there? Is this internal project really there? Are all these things real? And they should be real. And, much as we can tell, they are, right? So, but what has happened is USCIS seems to be working with the consulates because they're not asking these things and they're approving these visas. And then the consulates will ask for things like the third-party contracts, and they'll ask for things like the itineraries and what they're doing, but mostly the contracts. Who's the third party you're working for? What are they doing? Is it real? And all those sort of things, right? And if they don't have that, then they're sending it back to USCIS. And then USCIS is then issuing the notice of intent to revoke, saying, oh, it comes up that there isn't anything here according to this conversation. And they paraphrase the conversation. It's not made in front of anybody taking it down, no note takers or anything like that. They're just saying, we think they said this, and then you got to, fight that back. And that's why those are connected. Well, they're also sending out investigators, right? And so the investigators are having site visits. Site visits are coming up with information. If that site visit is coming up with something they're finding inconsistent, then they inform both the consulates and USCIS, and that can trigger it up. So you really need to know that the 221Gs and the site visits are connected to the H-1Bs. And if you're going into more H-1Bs, you really need to resolve these issues. And sometimes you can, and sometimes you can't, and sometimes you might need to litigate it. But that's what's behind all of this. So I want to now just say that's kind of sets the table. I'd like to know if anybody else wants to talk about what are they seeing, either as attorneys or companies. What sort of 221G issues are you having? If you'd like to talk about it, feel free. Please keep it confidential. Don't use people's names. But let's talk about conceptually the types of things that are happening. And I'm glad to weigh in. I just want to hear what you guys are thinking.
Thank you, John. So, if anyone would like to speak, just turn on your mic and feel free to speak. And if you don't want to, that's also cool. All right. I think not many questions.
Okay.
But I do have a question that came in online, so we'll go ahead and put it here from YouTube. Um, if I get an RFE on my H-1B, does that mean it will not be denied regardless of my answer?
If I get an RFE, does it mean it won't be denied regardless of my answer? Is that the question?
Maybe it was a typo.
Okay. Or
I'm
will
not
get denied or
sure.
won't get denied? Okay. Well, RFEs are important, right? That's called a request for evidence. That's where USCIS doesn't feel the case is approvable, thinks it's insufficient for some reason, and it will lay out what it thinks is insufficient. Okay, so there's a couple ways. Let's talk about RFEs and how to answer RFEs. So an RFE is a question which raises an issue and on a particular piece, and they can be for various reasons, right? So it's really hard to answer that question without knowing what the RFE question is. Sometimes it's factual, sometimes it's legal, sometimes it's minor, sometimes it's significant, right? So a minor one might be your passport photo is dark and we can't tell it's you. Would you please submit another copy of your passport? Probably pretty likely you're going to get that approved unless it wasn't you in the passport, right? Some might be they missed it, right? So you're doing a change of status or an extension, and you put in your pay stubs, or the beneficiary put in their pay stubs, and it indicates clearly that they were working up until the time they filed it, and they just didn't see it. And they say, well, we can't tell you're in status. Please give us paychecks. And you're like, I gave you paychecks already, but you just resubmit them, right? Here they are. Maybe you missed these. Maybe sometimes it might be something else. They want some verification besides just the paychecks. Maybe they want some taxes. Maybe they need a letter from the employer that they were there, whatever it might be. That's, again, a minor one. A more major one is going to be the reading of the law, right? We don't think it's a specialty occupation because you said it requires an engineering degree, and we think it requires a computer engineering degree, right? Well, that I'm citing that one because there's a case out there that came out at the same time the IT-Serve case came in. I think it's called XTC, in which they said the degree is engineering, right? And if you request an engineering degree and they have a mechanical engineering degree or a computer engineering degree or a civil engineering degree, the engineering is the degree, not the subspecialty, and that's what's required. Now, the tricky part is you may say it required a computer science degree, and that person has a mechanical engineering degree. And if you said it requires computer science, even though engineering is degree, they're going to hold you to that if it's the wrong one, and they're going to say, well, you asked for A and you gave B, and we're not going to be able to do that, right? But so that's in a distinction of a legal argument, right? Is engineering degree or is computer engineering degree are legal arguments. So when we look at RFEs, this gives us an opportunity to talk about this, and we have this great new tool called the RFE Responder that walks you through how to answer an RFE. So I want to take a second to go through that. So when an RFE comes, the first thing you need to do is identify the issue. And then usually they're saying that it's insignificant for some reason. So it's like, okay, do I have additional facts to give at this point, right? What is that fact? What is that piece of evidence? Label it, explain how this new evidence then, is going to be compliant to your question. Then sometimes you need that evidence identified or analyzed, right? Sometimes you need a witness. The witness might be the boss that says, yes, that person's still working for us, or somebody else that can verify something is what it is. or you need an expert. So an expert is not a boss. It's not a teacher. It's not a mentor. It's not somebody that has a vested interest in getting approved. But an expert can say, yeah, you think that this piece of technology is not significant. I'm an expert. Let me evaluate it for you. Here's how it is. And the expert may have already spoken about it, and they could then clarify it. I understand that you thought my expert opinion wasn't sufficient because of 1, 2, or 3. Allow me to provide further information or clarification or more evidence or more supporting evidence that my opinion is accurate. And then what we like to do is usually bolster the expert's opinion with a Supreme Court case that says that an expert's opinion, even if not supported by ancillary information, is evidence, right? And Beast Tech is the name of that case. So you can have experts. USCIS will not have an expert. Matter of fact, your lawyers in USCIS are not lawyers many times. Most times aren't, and they don't always argue by lawyers. So the way to argue as a lawyer is to have an expert evaluate it. So it's not just you saying it or your client saying it or a witness saying it, but an expert saying, here's what this means and why it's over the line. But then you want to apply the law, right? And so a lot of times people make mistakes of just saying, I'm going to answer your question. You said this, here's the answer. Well, really, laws are there, and the way lawyers argue things is they argue with authorities. So the first level is the plain language of a regulation, right? 8 CFR 2 point blah, blah, a blah, blah says. And then you put it out there and you say, it meets every prong of this. There might be 3 prongs in that sentence. They may be only looking at 2. It meets the plain language. The second thing you can then support is the policy manual or policy memos. Now, most of the policy memos have now been adopted into the policy manual. The policy manual's online. This is one thing to take away, guys. USCIS is training its adjudicators to follow the policy manual. They look at considerations. If you're looking at this evidence, consider this and consider that, right? One of the best things to do is understand what they're teaching. That's what we do at our team, right? Let's teach ourselves what the policy manual is so that we understand what they're looking at and how they look at it. So what that means is that their own bosses said you should consider this to them. The adjudicators are instructed to look at this consideration. Our client's evidence meets that consideration and the plain language of the regulation. Therefore, the visa should be approved, right? That's the second thing. The third thing that you can pull in are AAO decisions. Now, there's 3 types of AAO decisions. Most of them are non-precedent setting, meaning that they're not bound by them. Even if they approve the visa before, they don't have to do it second time. Even if they approve the twin brother with the same background, same petitioner, they don't have to do that one, right? It's non-precedent setting. However, they make decisions. They don't always overturn. They very seldomly overturn their own team. But when they do, they give you some language, and that language could be called persuasive, right? So we use this a lot, like in the EB1 or O1, that there's some language out there that say team awards count for the national and international awards, right? We have shared Nobel Prizes. That counts. Shared Olympic relay medals. Those count according to the AAO. So even though it's not precedential, we'll say the AAO has looked at this and they said that these team awards should count. It's persuasive. And the third is federal law. Those are case law, right? And that is the law, especially the Supreme Court. Every Supreme Court decision, they can't overturn it. And they're bound by it if the facts are there. Now, that's what lawyers do. Do the facts apply to this case, right? So there's some how you answer an RFE the same way how you answer a NOID and how you think about developing in the first place. And if you know that these 221Gs are happening to your attorney, to your clients, or if you're a client, they're happening to you, they're connected, right? Do not look at them in a silo. The 221G, while they're kicking you back, will likely have your next case done there. What's frustrating is the federal courts have instructed how the government should be looking at these to USCIS, and the State Department isn't looking at it that same way that USCIS is, and USCIS is looking to the State Department to ask that information they can't ask. That's what's happening right now. You need to know that going into the H-1B season. So there's some information right there. Does that open up any more questions, any comments? Anybody want to talk about that?
Yeah, and we have Attorney Yesh with us here. Hi, Yesh.
Hey,
Thank
Yesh.
you for being here. It seems like there's no
Hi,
questions.
guys. Can you hear me?
Yeah.
Yes, we
Hey,
do.
how you doing?
Oh,
We're
sorry about
talking
that.
about 221Gs today. Without divulging any confidentiality, do you want to talk a little bit about some of the 221s you're seeing and what you've done about them and how you've had some success with some of these issues?
Yeah, 221Gs. We is as you guys may know, it's the new RFE. Um, we are getting a lot of site visits. It is what we see right now is if you have beneficiaries going to the consulate in other countries and the beneficiary is issued a 221G, um, within a week or two, we are seeing FDNS officers reach out to the companies or the petitioners here, trying to get some information about, what kind of projects these beneficiaries will be working on, how many employees does the company really have. They're actually coming and knocking on the doors to see if there's anybody working out of these offices. Um, it's still completely voluntary to respond to these questions.
Mhm.
We highly suggest that you let the officer know politely that you have an attorney, or you'll take their questions and then forward them over to your attorney so that we can get in touch with them, because we don't want you to admit something that in the heat of the moment, or if you're stressed, say something incorrectly, and then it's three times as hard to get the right answer or that answer corrected.
That's
Definitely
a
do
great
reach
idea.
out to the attorney. Um, Another thing is, these officers will say, "I need an answer within the next 24 hours."
Yeah.
That is that is just them trying to push you.
Sure.
That is not the case. You do have some time to, get your documents together. Let your attorney know, and your attorney should be able to reach out to the officer and say, "Hey, we need a week," or we're just hired for this case. We're gonna get back to you with all of your answers, and take your time. I would rather have you take an extra 2-3 days, rather than rushing through and answering incorrectly or contradicting yourself when you answer,
Those
versus
are
what you've
good.
originally submitted in the petition.
Excellent pointers, yes. And I just kind of took people through like how to answer an RFE, and maybe I can give a couple pointers here on why you should have an attorney answer, whether it's an email or from a consulate or from an investigator or anything. First and foremost, remember every cop movie you've ever seen. Anything you say can and will be held against you, right? Anything that is an addition to what was in the LCA and in the I-129 is now being put in a file. I guarantee you it will be in there. It may not be used against you now, but it could be used against you later, and you should know that. If it's inconsistent, they can use that inconsistency to deny your case. Anything you say is an admission. Anything your attorney says is not. All right? That's really important to know the distinction. Secondly, you're emotional about it. This is your business. This is important. It's keeping you up at night. Your spouse is worried about it. You're worried about it. Your employee's worried about it. Let somebody that's not having the same types of anxiety, somebody professionally can answer that, to answer those questions. Thirdly, those aren't easy questions. There's a couple of things that there can be hidden in these questions, right? They say who is the supervisor at the end client? If you answer with anybody's name to that answer, you've effectively said they're the real employer, and they can deny your H-1B for it. They may not, but they can, right? How you would really answer that is the supervisor of the beneficiary is the HR director or the lead engineer or the CEO or whoever it is at our company, right? We have a contract with this other company, and we're providing our services through our employee to go to the location or sit at our location to do these works. That is not a supervisor of my employee. That is a manager of their project. They may call themselves a supervisor. That doesn't matter. They cannot hire, or they cannot fire my employee. They can fire me as a company. I can only fire my employee. They don't have that right. Okay, so that's a really important way to answer it. You also don't have to answer any of the questions you don't want to, and you can answer the questions with another answer before you do it, right? What I would say is what I told you. We are the employer. We are the supervisor. Now, the person over there, if you want to know who they are, that's this person, and they can contact you and those sort of things. So there's all sorts of things that you can do on this thing. What Yes says is absolutely right. If they are coming at you, trying to get you done, they're doing that on purpose. All the reason for an investigation is to deny a visa, right? That's the only purpose. They're not just checking to see how you're doing. Hey, we're here with the U.S. government. We just want to make sure you're having a great time in the United States of America. It's not it, right? It is, we are going to investigate to see if there's an inconsistency. And if there's an inconsistency that we think significant enough, we're going to revoke that visa. We're going to deny that visa, right? Those are the things you have to be worried about. And they are tied, and it can really mess your company up. Or your individual thing up. And the whole thing is, and I can go in a lot farther on that, but I think that's some good advice for today. I hope that's helpful to you. Yes, thank you so much for your insight. But back to you, Pierre.
Excellent. Thank you, John. And thanks everyone for joining. I think today we gave them the drip of the conversation, but to everyone watching us on YouTube, thank you so much. We have about 20 folks that are watching us on YouTube
Right.
live at the moment. Please join us next Friday at the same time, which is 12:30 p.m. Eastern or 11:30 a.m. Central, for the follow-up conversation on the entire H-1B situation that's going on, to 21Gs and site visits. And I think next week we'll go in more depth if possible. Now, John, I know you're going to India next week. Will you be with us, joining us remotely, you think?
I believe so. I'm going to try to. It's the other side of the clock, but I'm glad to. I'd love to do it from there. It's we're there to see the uptick, obviously, of our business, and we've got clients there, and we've got some of our workers there. And it's a wonderful country, and I can't wait to get over to Hyderabad and spend some time.
Excellent. Well, thank you so much for your time. I know we passed the hour today, and we'll see you next week. And just for everyone watching, you can always scan the QR code to book your strategy session with John and his team, or you can email information@velielaw.com. We'll pull that up really quickly just so that you can go ahead and write it down or take a screenshot of it. And with that being said, again, thank you for joining us.